This is a time set for oral argument in Andaloro versus Andaloro, CV19 839FC. Council, good morning. Each side is given 20 total minutes. We have an appeal and a cross appeal, so if you wish to reserve a portion of your time to respond, you'll need to keep track of that. I will do so on my cell phone as I indicated as well, and let you know when you sit down for the kind of sit down for the first time, how much time you have left. We have reviewed the record, we've conferenced the case, we're familiar with it. We'd encourage you to keep that in mind as you present oral argument, and our argument is being recorded, so please, as you begin your presentation, tell us your name and the party that you represent. With that, Mr. Katz, you may proceed.
Thank you, Your Honor. Good morning and thank you. My name is Norman Katz. I represent the appellant in this action, Lori Andaloro. Main issues for this court to decide are whether the trial court abused its discretion in calculating the amounts of support for both spousal maintenance and child support, some division of property issues, and attorney's fees. There are a few miscellaneous issues besides that, but those are the three biggies. Turning to the first one regarding spousal maintenance. The court award of $250 a month is not at all supported by the record and not by the actual findings, some of which we dispute, but given those findings, they still do not support the award of the $250. Therefore, it's our contention that the court abused its discretion in calculating that final award amount. If we look at the actual findings, we see that father earned an average of $440,000 per year for the 4 years preceding the filing of the dissolution action. It's a long-term, long-duration marriage of 25 years. Mother did not work for 20 of those years, raising the party's 7 children. The court found the parties enjoyed an affluent standard of living and that mother's current income at the time of the decree was $37,000 per year. The affidavits support of financial information submitted by mother showed her need, which far exceeded the $250 per month that the court ordered. The court also found, specifically on page 22, that the evidence provided did not support a finding that father is unable to find employment. He has a PhD in pharmacology and is capable of earning a substantial living. Court does not find that father is unemployable or that the medications he is taking prevent him from being able to find employment. We also know that father has no known expenses that were set before the court. He did not submit an updated affidavit of financial information, and the evidence presented shows that his girlfriend with whom he lives pays for his expenses. Given all that, it was clear error for the court to come with a $250 amount, especially if you're giving father, and I forgot, the court did attribute father $125,000 in income.
Did the court do that for spousal maintenance, or was that for other purposes?
Well, in the decree, it's set forth there for child support purposes, but one can only extract from that it was for the spousal maintenance as well, because it has to be based on what his income earning capacity is. And that would be the same for both of those issues. So even if we look at $125,000 a year, that $250 a month, that's $3,000 a year. That's just, it's an unreasonable amount, not at all supported by the record. If we actually look at the $125,000 a year that was attributed, that was clear error. Father's earning capacity far exceeds that. He, as noted, his earning history was $440,000 per year with a high of over $750,000 per year.
Historically, father had earned significant amounts above what the court attributed to him in the order of the decree. But wasn't there evidence that allowed the court to conclude that there had been substantial changes in his earning capacity in a negative way leading up to the decree?
No, not at all. The record is devoid of substantial evidence of that. The court specifically.
Let me ask you a more pointed question. Wasn't there conflicting evidence that the court could have found that father's earning potential had decreased?
We don't believe that evidence is substantial or credible. And that
wasn't my question. That's why I modified it.
Well, I would say no. There was not conflicting evidence. Not all evidence is created equal. And so if we look at what the actual... I agree
that not all evidence is treated equal, but you're saying there's no evidence that the court could rely on to find, none, that the court could find that father's earning capacity had diminished by the time of the entry of decree.
That's correct. And if we look at the findings on page 22 that I already cited, the evidence does not support a finding that he's unable to find employment, he's capable of earning a substantial living, and the medications he's taking do not prevent him from being able to find employment. So if he can find employment at $125,000, and he can work a full-time job in that aspect, then there's absolutely no reason he can't work the same job he held for most of his career up until the dissolution. You can either work or you can't. And if the court found that he can work and he can engage in full-time employment based on his PhD in pharmacology and his experience, then he should be held to his actual earning capacity. There is no evidence to establish why it should have been $125,000 instead of the historic average of the $440,000. Our position, and I think the evidence clearly showed that that reduction in income was absolutely voluntary and caused solely by father.
Was there conflicting evidence on that too, or are you saying there's no evidence?
There's no evidence that the court should deem worthy in that situation. Again, because we have the actual records that we subpoenaed from the employer. And not only do they not support what father was telling the court, they absolutely contradict it. This is not an example of where the employer was trying to get rid of him for some unstated secret reason. The records clearly state he was a valuable employee to them. He had won the award for the 2 years preceding for being their top salesman. And if you look at those records in the parts that I cited in the briefs, it's clear they gave him every opportunity to get back to where he was. They wanted him to stay. They put him on a performance plan. They met with him repeatedly. And it wasn't until he basically told them, no, I'm no longer going to do this job, that they finally said, okay, you're going to have to go. Those were his actions, and they were completely voluntary. There is nothing in any other evidence and anything to support father's contention as something opposite of what the records absolutely show. And then if we're actually going to look at what the father's testimony is, there are serious issues with his credibility, and I've pointed those out in the brief. He misrepresented the reasons for leaving that employer, which the subpoenaed records show.
Let me ask you, counsel, isn't credibility call something the trial court does, not this court?
Yes, but it's not based, I'm not asking that the court should have based it on just his credibility because, again, we have the actual records, the actual subpoenaed records, documents from the employee, and that's what the court needs to rely on. Those are the actual proof of what's there. If the court has no further questions on that issue, I was going to turn to the division of property now.
Very well.
Okay. Our position is that there were community funds held in bank accounts in father's sole name at the time the petition was filed. Those needed to be divided equitably or equally, and basically father kept all those funds. That was an error by the court to not award mother her share of those funds. Father's contention that he spent those funds on community expenses is incorrect under the law and the facts. Claiming that he spent mother's money to pay her spousal maintenance, child support, and his own personal expenses is simply not a defense to him being awarded those funds.
Counsel, how much were in those accounts that were awarded to father?
I have $135,225.87 in account 1551 and $11,373.92 in account 7927.
And where would I find that in the record? If you don't have it, that's okay.
I don't have the site right there with me. I'm sorry on that. I do believe that the specific reference is cited in my statement of facts in my opening brief. Last issue that I wanted to address just very briefly is just the attorney's fees issue. I think the court, again, abused its discretion in not awarding mother some attorney's fees in this case. The record clearly establishes father was unreasonable in the positions he took, especially regarding the legal decision-making and parenting time, not resolving those until the day of trial and forcing mother to incur tens of thousands of dollars, misrepresenting his income. And then the trial court very obviously made an error in citing a reason why mother was somehow unreasonable, alleging that father filed a motion to compel, and that's the basis for mother's unreasonableness, when it was actually mother that filed that motion. I think based on the review of all the records, it's clear father has greater financial resources, and there should have been an award of attorney's fees.
Counsel, let me go back, if I can, to the division of community assets, specifically the proceeds from the sale of the home.
Yes.
If my recollection is correct, there was about $185,000 that was held in trust. The court awarded, I think, about 85% of that to mother, about 30 or 15% to father. Father's contending that that was not an equitable distribution. Help me understand how that was equitable.
Well, what the court did is considered all the circumstances as they're required to do under the Emboden case. And I would also point out that in those areas under that case, the court has broad discretion regarding that issue. The court noted it considered not just one or two issues, it considered the entire record, every issue set forth in the decree, which encompasses all the actions, all the issues throughout, all the assets awarded to father, how the expenses were allocated between the parties, as well as the court's other orders in there. Taking that all into consideration, as well as I think the evidence establishing father's earning capacity, the history of the case, the court was well within its discretion to order that equitable distribution. Okay. If there's nothing further, I'd like to reserve the rest of my time, Your Honors.
Very well. Thank you, Mr. Katz. I have you with about 10 minutes and 30 seconds left. Okay. Thank you. Mr. Berkshire.
Thank you. May it please the court, Keith Berkshire, attorney for the appellee, Vinnie Andaloro. As you were stating, Judge Thumma, I think that a lot of this does come down to credibility issues. A lot of it is admittedly factual, and obviously on any factual credibility issue, your deference to the trial court is pretty large. The issue we have with some of these rulings, and specifically like income attribution or the failure to modify spousal retroactively, is simply based on the other court's findings. So I'll start with the spousal maintenance. I don't want to call it a modification because it's just the final order on spousal maintenance. Under 25.315, spousal maintenance temporary orders essentially have no prejudicial value towards any final order. So in this case, we have where admittedly my client had a large salary at the beginning. The salaries that Mr. Katz cites repeatedly in his briefs that were historic or accurate. The issue is what happens when those incomes change. And so in this case, in citing to your this court's Maximoff case, when those things change, then the temporary orders, or what it is really just affirmation through a final order, should be modified. So here we had an order that went into effect for temporary support in April, where he then lost his job later that year and went from a very significant salary to a salary that was about a third. And the temporary order essentially stayed in place. Admittedly, there were various motions and hearing continuances because of that, or because of his mental health, but that doesn't change the fact that the court then adopted this lower income for my client. And at the same time had a temporary support obligation between child support and spousal maintenance that equated out to 80% essentially of the salary that the court found he was making. So when you go back and if the court found that based on $125,000 income, and I'd agree with you, Judge Thumma, that wasn't a finding in the spousal portion, it was a finding for child support only. But if you did that, it's hard to come up with a $7,000 support amount when you're making $10,000 a month. I mean, that is, if you just taxed it, your income, you're at essentially zero to live on. And that relates to one of the main problems we had, which Judge Williams brought up on the House, which is how do you come up with these numbers? How did the court come up with this calculation of what happened retroactively, what happened, why the House award was so disparate? Which is the court didn't actually say how it came up with the calculation. It basically said, in light of everything, I'm doing this. The problem is that doesn't meet the statute for spousal maintenance, and we specifically have a statute that says if you award property in lieu of spousal or child support, you have to say why. And here the court basically said, I'm looking at everything and just coming up with a number. I mean, it wasn't any calculation. It's just husband gets 30, wife gets the rest. There's no basis for that essentially on how that was calculated. One of the things I think of that award on the House, of why these two relate, that's the most disturbing, was basically saying, well, if husband would have been earning more money, he would have paid more spousal, so therefore I'm giving more property in lieu of that. Well, spousal is based on the statutory factors, not if he would have been earning more. It's what you are earning, his capability at that time. So the court adopted, I'm going to attribute you $125,000, but if you would have been earning more, but since you aren't earning more, I'm going to give them more property out of the house. And that's just, conflating those two statutes, which we don't think the court has the ability to do. Going back to, it's why all these things I think are somewhat interrelated, because the court's final ruling on the House made them related. Well, based on arrears he might owe or child support or attorney's fees, here's a number, without any sort of calculation of where that number came from. And again, it's pretty disparate, as Judge Williams stated.
Mr. Berkshire, let me ask you, is there any relationship between the House award, or the award of the value of the house, more accurately, I suppose, and the apportionment of the bank accounts that were held in father's name? Or do we know?
From a generic statement of what the court's, one line on that says in the order, it's after considering everything, including everything, this is what I'm awarding. So I guess it could be fair to assume that that was considered, but it's hard to, when the court, if the court was just doing property, like I've considered the disputed value on these 27 assets, and I come up with party A owes party B X dollars. I think that's a more appropriate analysis, especially if values were disputed and use of funds in those accounts were disputed. But when you start conflating spousal maintenance into that and arrears and other things, I think that's more of the problem, that those spousal maintenance, as we quoted in our brief, spousal maintenance has a completely different set of statutes and different presumptions than the property award. So if it was just that, Judge Thumma, I would say I'd have less of a problem with it, because especially if there's disputed values, disputed expenditures out of this, like the repair guy and those things that were disputed. But since you added in support, that's where I think the legal conclusion problem it comes about, because those things just aren't the same. They're not, especially with this retroactive claim on it that was made at trial and not waived. So I think that's where my bigger problem with it comes. But so a long-winded answer to your simple question is it could be, but.
Well, no one seems to like the spousal maintenance award, but for very different reasons. What are we to make of that?
Again, a typical spousal maintenance appeal is discretionary as attorney's fees. It's, typically from doing the number of these I do, the Court of Appeals likes those fact-based credibility issues, right there with custody. So, but here the issue is an income attribution issue where, which then implicates cases like Pullen and Little that talk about, what the court has to look at. And here, the findings are what both parties are somewhat citing to. And our findings that support us is where the court repeatedly says, he had mental health issues, these types of things. I want to step back on 1 second on this. And this is a kind of I don't want to say atypical, it's probably a more typical case of where you have a claim at the beginning of the case that the party's too nuts to have parenting time and they shouldn't be near the kids, and we filed 27 motions about why they can't be near the kids because of drugs and mental health and these things. But they also at the same time can be the head of the Algonquin Round Table. It's this, they're axiomatic to say they're so mentally ill they shouldn't see the children, but they're fit enough to do the highest paying job on earth. And that's what happened here, is that you pick in the situation that is convenient to you at the time of he's perfect and can work and is the greatest employee ever, but don't be near the children because of the same mental health issue. So what we had is you do have evidentiary issues on just, the nurse practitioner. Admittedly, we misstated that she was called her doctor. The nurse practitioner, which is in those facilities essentially similar to a psychiatrist, because they're psychiatric nurse practitioner, talked about why he was treated, what his things were, and those forth. Not as an expert witness, just as factual based on what happened. We had a therapist testify and we had my client testify. So there was clearly evidence both sides of why he could or could not work. The issue we have is based on the court's findings that he has mental health issues, and you go into the custody findings that, we're denying custody and these types of things until he works on his mental health, or until he gets, hopefully his mental health is better. Those things seem under Pullen to basically shift the burden to say, yes, it wasn't a voluntary reduction in pay. This was based on something else. And therefore, when you start from that standpoint, that the court obviously believed he had mental health issues, how do you get back up to 125? It's that the court found he had mental health issues. Then, okay, how did we get back to that number? And that's our complaint here, and is based on the findings. The findings essentially don't match when you find repeatedly that he has mental health issues. It's, well, but we don't think they're to the extent that can prevent the employment at that level. That's our first challenge on the spousal maintenance. The second challenge on the spousal maintenance we have is what we allege meets the test under the Sherman case. This, I'm going to leave the door open in case you make more money, spousal maintenance award. And in Sherman, based on the prior Supreme Court case about this concept, is, there's no bright line. Obviously, the old standard of I'm going to award you $1 to leave spousal maintenance over. This is more than the dollar that the Supreme Court complained about, and more than the $50 in some of the later cases. But when you look at the court's findings on this issue, and there was specifically in making this award, the court stated, I'm doing this so that father can get a higher paying job and modify in the future. Well, we have plenty of case law in Arizona that talks about that the payors increase post-decree in income is not a sufficient ground by itself to modify spousal maintenance. The case law is replete with that fact alone. So the court here clearly did that. I'm going to award 10 years so that he can get a higher paying job so she can modify it. That's why we believe that the spousal maintenance under Sherman, that we have an issue there, because essentially the court said so. I mean, it said here's $250, and the findings right in that section, specifically discuss that context of why the court's doing it.
Mr. Berkshire, let me ask you, and Sherman did condemn nominal spousal maintenance, but what is more difficult, I think, is identifying what is nominal spousal maintenance. And you have said that the court, expressed concerns about father's ability to earn more. What's your best case for the proposition, other than the amount of it in this case, that this spousal maintenance award is nominal?
Your Honor, it's hard to pin down those numbers, because when the Court of Appeals comes out, I mean, frankly, trial judges are intelligent beings, and when the court comes out and say you can't do $1, they do 50. When you say you can't do 50, they do 100. It's one of the things, like under the custody statute, you asking me what is maximizing parenting time means. It's the old I forget the Supreme Court justice that said it on the pornography case. You know it when you see it.
Right. Well, and I'm with you there, but that doesn't make our job any easier in identifying what it is and what it is not.
I mean, I think that, again, the reason I'm saying that I think it falls into the nominal amount is the sentence that in the ruling on page 16, where it says it will also allow father to obtain suitable employment after his mental health issues have properly been controlled, to return to a well-paying job and allow for future modification of this award. So the intention of, okay, this is to hold it open. I mean, the Sherman case talks about not just leaving a door open to future modifications. That sentence is what I have the problem with, is where the court is specifically almost saying, I'm doing this to allow you to get back to something that I hope you get back to, and allow it.
And I understand that. Now, I don't have that decree right in front of me, but that sentence talks about other things as well, right? Because it will also allow father. So
it says it's ordered effective November 1st. Father shall pay mother $250 for 10 years. The 10 years will allow mother the time needed to secure additional employment and arrange for any training needed to secure appropriate employment. Then it will also allow father. So again, it's that, I don't want to say reading between the lines, it's reading specifically the lines of saying that he can get back to this. And that's where we have the problem. And again, a $1 award is a no-brainer. I mean, you might as well say this is Sherman. But, in these amounts, I think you run into this issue of what is the appropriate amount and so forth. And that's why I think you have to read the findings in totality to say, is this what the court intended by this? Is the court intend that he can then, hopefully work on his mental health issues to get up to a higher income? Obviously, this is an easier case if he's making $750 at the time that they're getting divorced. There's plenty of money to go around here. But when you read what the court wrote, and especially in conjunction with the other findings about spousal maintenance, that's why we believe that it's a violation of the Sherman case. Admittedly, the amount by itself, Your Honor, I think you're, on the line of what it is. I think if it was $50 or $100 or $75, I think it's a lot easier case for us than at $250, because that's an actual amount of money. And there's a lot of trial court cases that award $250 in spousal maintenance, usually not at $120,000 of income, but maybe at $50,000 of income or something, but so forth. Okay, so on the other, the attorney's fees claim made by wife, Again, as I said earlier, I think attorney's fees are about as discretionary as they get. The court found both parties unreasonable under certain things. Mr. Katz does appropriately cite that there was a motion to compel referenced by the trial court inappropriately. However, despite it not being a motion to compel, there was a motion filed by father on that issue called a motion for clarification regarding the non-payment of the house mortgage where he had done that. So the court misclassifying which motion it was, we don't think is some demonstrative error on what that the court was inappropriately denied fees. As far as the incomes go for fees under the other prong for resources on attorney's fees, very discretionary. The court found, on what he was making or potentially making, but his actual resources and the limited resources that both of them had. I mean, you had basically some accounts and the house proceeds, and again, the court was utilizing some of the house proceeds to pay wife her temporary spousal maintenance. Sorry, change screens back to my notes. The main issue, I mean, I think that it's fair to say that the main issue out of both parties' briefs here is just that the issue of his earning capability, which then, we believe under our situation, you'd apply a de novo standard because the court, of applying somebody back up to a higher standard versus what the facts said. Their issue is, was he mentally ill? And subject to a lower earning capability. Ours was, now that the court found that he did have those mental illness, why did they attribute a higher income? And we think that's the distinction between the two standards of review, is they want to challenge the court's findings on his mental illness. We're saying with those findings, how can you have the conclusion based under Pullen that he can get back to this higher level of income? Trying to make sure there's like 12 issues between the two briefs, which I know you guys love.
There's much at issue here, Councilor.
The discovery sanctions issue that they raised, again, the court found. The court did make findings on that in various rulings about the substantial compliance and so forth, and that both parties had discovery issues and failures to disclose. The bank account issue, beyond the, I'd point out it's very limitedly addressed in the pretrial statements. They addressed it not as he had bank accounts of X as of the date of service in their pretrials. They addressed that at some point in the prior year he deposited so much money. So this wasn't a specific, please divide these two accounts. If you look at the two pretrial statements filed by Mr. Katz, they were more on, hey, during this, they were more on the issue of, did he, these deposits during the prior period, and essentially the court looking at that, I don't think made any specific findings about whether either party proved there was dispute. There's basically factual disputes about where the money went and so forth. And the court, you can see in the ruling, in the whopping couple sentences that were there, talked about that, there wasn't just evidence on where some of these money went, or on husband's claim that wife took $100,000 out right prior to the date of service and where her money went. So there was factual disputes and testimony on that. The fees on Dr. Lavitt, again, discretionary, the same as the standard of fees. Sorry, Your Honor, I wasn't totally paying attention when I started. Do you have
You've got about 90 seconds left, all up.
Again, I think, I'll spend my last probably 70 seconds at this point on the concept of the retroactive spousal. I think that's really a big issue because it goes into the property of how can you basically keep a $7,000 reward for a period of years. I mean, this was a couple of years, essentially, by the time this case was over, when the court found at the same time, at best for child support purposes, $120,000 income. And so when you calculate that, and again, the court allowed wife to take her share of the husband's portion of the house and these types of things, that's a pretty large amount when you go for $7,000 a month during this lengthy case of how does that match the other court's findings. If the court found, hey, after he lost his original job at PPD or whatever it was, that he could only make $120, then that spousal maintenance award and the retroapplication would be a little egregious.
And counsel, with the retroactivity of the spousal award, that it seems like that kind of morphed over time to the point where it became really a request for a credit at trial as opposed to retroactive modification. How do you respond to that?
I think to some extent it did. I mean, the issue was that we specifically cited in our reply brief about, or the cross appeal reply brief, the statements of my client's trial lawyer on that issue of how he kept it open. But I mean, when you're dealing with the house proceeds and the things like that, I don't know if it really makes a difference, but it was saying, hey, account towards everything else I potentially owe here, meaning any account, house, anything in the equalization, because that's the reality is you got to come up with a number at that point. But there's nothing in there that shows the court ever actually did it. Again, in the minor statements that you and I talked about earlier, Judge Stama, on the where the house came out. So I think my point is that it was alive, and however the court dealt with it, they should have dealt with it.
Counsel, thank you. Let me look to my colleagues. Any questions?
Just one follow-up question, Mr. Berkshire. This is to the distribution of funds from the sale of the residence. I'm looking on page 18 of the decree, and the court specifically says this case makes a finding. This case does present a unique set of facts or circumstances. Therefore, an equal division of community property is inappropriate to achieve equity. Is it your position that this was not a unique set of facts, that the equitable division needed to be substantially equal with the proceeds of the sale of the home, or can you touch on that briefly?
I think to some extent it was what I was discussing earlier, was then later in the decree they talk about in getting the amount, and they talk about how the amount wife would receive would be because of spousal maintenance arrears and these types of things. So in the unique set of circumstance, if you read the next part of the decree where it talked about how each would get out of what they'd each get out of the house, that it appears to have considered a circumstance regarding spousal maintenance in that, which I think again would be the distinction that's needed between those two. So I don't disagree that they have the Toth type statements in there, the court did, but then when you look at why later on in the decree, they talked about what their why was, and I think that the reasoning was the issue I have.
Okay, thank you.
Thank you, counsel. Appreciate that. Mr. Katz, rebuttal, you have about 10 minutes and 30 seconds.
Thank you, Your Honor. Just going back to one of the first issues that was addressed, the claim that father's mental health, if it affects his parenting, then it must therefore affect his ability to work. There's no basis whatsoever for that kind of a claim. The issues of father's mental health were established in the temporary orders hearing by members of the immediate family, including some of the children, and these were issues that went back years, clearly during which time father was earning vast sums of money. So with his mental health history and the issues there, he's always been able to work. So it's never affected that ability, and we have the actual court findings that his ability to work is still not affected, and the evidence didn't establish that. And again, those are the findings on page 22, that the evidence does not support a finding that he's unable to find employment. The medications do not prevent him from being able to find employment. So again, if we're attributing income, there's no distinction made as to why it should be the lower number and not the historic number. Also point out, as far as the custody findings in there, those were agreed to by father at the day of trial. So that's not something that the court found on its own. It's based on his representations. With the issue regarding the claim that somehow this is akin to the Sherman case with keeping the door open, I set forth in the briefs why this case is clearly distinguishable from that finding. The facts on that case are just completely different. Both parties in that situation were entitled to spousal maintenance. And the court clearly noted that it was done, the orders entered were done for the sole purpose of keeping the door open and no other reason. That's not at all what we have here. We have an absolute justified claim of spousal maintenance that really didn't seem to be disputed, her entitlement to it. It's just a matter of whether or not he had the ability to pay or so on. In the 10 years is not done solely for the purposes of potential future modifications. And the court noted that. There are other reasons. Not to mention the 10 years is certainly warranted under the factual history that we have here concerning it's a 25-year marriage, 20 years of which mom didn't work, and given the incredibly large income disparity between the parties. So the court wanted to give mother sufficient time to be able to become self-sufficient. And I'd also point out that the court's findings do not say that even if she did get a nursing degree or anything in the future, that would be able to provide for all her reasonable needs based on a comparable standard of living. That finding is not there. What the court found is she would be better able to start meeting her reasonable needs. So the duration is justified under the facts, and there's no issue regarding the Sherman case on that. Briefly, just with the issue of attorney's fees, it's a false equivalency to say that, well, father forced mother to incur tens of thousands of dollars in attorney's fees on fighting all these issues, including subpoenaing the records, and somehow that's going to be washed out by the fact that father filed a motion for clarification that was summarily denied by the court. That cannot be an equal basis for determining an award of attorney's fees. I understand it's discretionary and within the trial court's discretion, but based on all these factors, it appears to be an abuse of that. Regarding the sanctions issue, just briefly, a big concern, of course, was the fact that father did not have to submit an affidavit of financial information. And we raised the issue, saying that he should be sanctioned appropriately on this. The last one he had submitted was quite stale and really provided the court with no useful, or us, with any useful information going into trial. And that's a critical piece of information, especially in this case, when it would have revealed exactly what financial benefit he's currently getting. We know that he was living with his girlfriend, and she earns a substantial salary that was disclosed at trial over objection, and we got that out. And so we would have had a better sense of what funds he has access to, what expenses are being paid, but he didn't have to provide any of that information. And so to go in there without the most basic fundamental information in a spousal maintenance and child support case, our position is there should have been some accountability for that. In contrast, the court decided to sanction us for what I would contend was a trivial transgression of submitting a post-decree motion that was 3 pages too long, which we acknowledge it was, but the court certainly had other options, especially in light of its refusal to issue any other sanctions for any of the other transgressions. With respect to the issue regarding the retroactive claim to modify, as Your Honor noted, that I think you said that it morphed into a claim for credit. That was the claim at trial. That's what they were asking for. It was clarified. It was not mentioned in the pretrial statement. We discussed it ahead of time in chambers, and it was again addressed on the record. And those citations are in the statement of facts in my brief. And it was clear that he was not proceeding with the retroactive modification claim, but only seeking a credit for the amounts that he had paid. The issue was not litigated. There was no testimony on we want a retroactive date to this date or this, or what the circumstances would have been during these individual time periods. So that is not an issue that was properly before the court, and it was, for all intents and purposes, waived. Just bear with me as I go through my notes here. So again, just turning back to the main issue as to the amount of income to be allocated, it appears father's still saying that it should be 0 or minimum wage. That's a little unclear. And again, I would maintain that that's still a very unreasonable position, especially in light of the court's findings. This man earned substantial income. He's capable of earning quite a substantial income. He's still capable of earning $440,000 a year. And even if we look at the $125,000, like I said, to give mom only $3,000 a month when she's a school teacher raising 3 minor children, that's just, it's not reasonable. It's not supported by the record. And frankly, that's a clear abuse of discretion that we're asking this court to overturn. Just bear with me here. And I would just remind the court and it's cited in the statement of facts here. We believe the evidence showed that these were intentional acts by father to reduce his income. He foreshadowed it to mother. We have the communications pre-trial, pre-filing of petition for dissolution, warning her that if she went forward, he was going to do what he did. He threatened he was going to take a lower paying job. He warned her, please understand, I need to take care of myself, my future life. If what happens in the future seems unfair to you and our children, please try to find a way to accept that you did this, not me. He then prepared for his future. He started earning tremendously more than he had earned previously, while absolutely lying about what he was earning, repeatedly texting mother. And the record shows, these were entered as exhibits, texting her, I'm not making any money. My sales are in the tank. There's no commissions. This is why he's having by far his greatest year ever. He then came to court on the temporary order and said, I only make $14,000 a year. While at that time, his actual income was over $63,000. I mean, $14,000 a month, and his actual income was over $63,000 a month. Mother had to spend a tremendous amount of attorney's fees litigating these issues, getting the records, fighting them. It's unfair to hold her accountable for what father did. The evidence showed this reduction in income was 100% voluntary. We look at the Little case, we look at the Patterson case. The court should have found he was attributed the right amount of income. The court made correct findings. He's capable of earning. He's capable of working full time, and that his mental health conditions, medications do not affect that ability. The court just got wrong how much to attribute and how much to order for spousal maintenance. I think I've covered what I want to cover. I don't know if there are any final questions by the court.
Let me look to my panel mates. Any further questions? None at this time. Counsel, both attorneys, thank you very much for your presentation today. Thank you for your briefing. You've given us much to think about. We will take the matter under advisement, and we will issue a written ruling in due course. Have a good day. Stay safe. Take good care. Court is adjourned.
Thank you.
Thank you.